All right, well, I just had a little bit of energy. I don't know, I had to take a little nap after work today. Today is that daylight savings time. November, is it the 3rd today? Sunday? Is it the 3rd? 5th! Where have the days gone? I can't believe how, wow. Guess I gotta pay some rent. Anyways, I was so tired after working and then had some Indian food, went to the dog park. Karma got in a fight over there at the dog park. She had a part of the dog's fur in her mouth. Poor doggy. Was that doggy too extra fluffy for you and you couldn't handle it? Is that what it was? Well, I was in the study group. By the way, if anybody wants to join the study group, find me Haya Shalom on Facebook, Messenger, Telegram, and say, I want to be put in the study group. That's it. And I'll put you in there. And then we can share files and our experiences and, help each other out. I don't really allow any selling, no cryptocurrencies or nothing like that. No abuse, no cussing and stuff like that. People, I think, we could get triggered very easily, and some of us can feel very dysregulated. What that means is when you just kind of get brain fog and you just can't think straight. So sometimes sleeping helps, but we don't need to be triggering anybody and causing more trauma. When we're learning about new things, it's a lot of information. We don't really need to be having any battles. And so that's where you put your boundaries up and you say no, and let them know again, no and no. And then after that, well, you got to maintain those boundaries. So we have to pick our battles, right? Anyways, I want to share the screen because, let's see, please work for me. Oh, yes, thank you. Sometimes the mouse doesn't work, and I want to see if I can make this a lot bigger. We can look at this, the truth about trust. This is in our group, in Reconnaissance group. And we had this way back from 2020 when we were called the Radiant Clone Group. And then we changed the name to, what was it called? Secured Party and Creditor. And then we changed the name again to Reconnaissance Study Group. So I'm going to read this because it was in the group. And, sometimes on Facebook, those PDFs or whatever, they disappear, but this is still here. So I'm just going to read it. And hopefully it's going to be all good and we'll learn something. So The Truth About Trusts by Glen Halliday, Trustee. The trust is an excellent tool to protect assets, avoid probate, increase personal privacy, and minimize income taxes. However, trusts are underused and frequently misunderstood. This not surprising when you consider the scarcity of written material on the subject. According to a Trustees Handbook, 7th edition by Loring, in the late 1960s, law schools set about the process of downgrading courses in the law of trusts from required to elective status. So like when you go to school, they require you for your certain degree to take these classes. But what they've done was they changed it over to elective. Like if you want to do like an extra credit, like pottery or painting or something, they changed trust law into an elective course, elective status. So that while almost all law schools have made courses on state regulation mandatory, only a few continue to afford the law of trusts the status it enjoyed at the turn of the century. In most law schools, trust law is now an afterthought, buried somewhere in an elective course on estate planning. Likewise, in the preface of Income Taxation of Trusts, Estates, Grantors, and Beneficiaries, author Jeffrey Pennell states, unfortunately, when I first recommended to our curriculum committee that we add a course on this subject, there was simply no classroom text available because trust literature is seldom published. Let me see if my volume is up. Yeah, it's up. It is virtually impossible to go to any single source to get all the reliable information about every benefit of trust. Further, available information on trust has been complicated to the point that the average person has almost no chance of understanding even the basic principles. However, the information is out there if you know where to look. The basic principles of trust and their management are relatively simple, and proper operation of a trust is no more difficult and often easier than running your basic small business. Okay, there is no mystery surrounding trusts. Is that right? It is true that they are less known than other types of business organizations, but they hardly uncommon. I think they have some editing issues here. In 1993, there were approximately 1.6 million tax returns filed for partnerships, more than 2.5 million tax returns, Form 1041, filed for trusts. Did you hear that? 1041, not 1040, filed for trusts. And 4 million returns filed for corporations. So let me go over that again. In 1993, there were approximately 1.6 million tax returns filed for partnerships, more than 2.5 million tax returns, Form 1041, filed for trusts, and 4 million returns filed for corporations. In other words, trusts are more common than partnerships and comparable in number to corporations. Further, the audit rate for trusts is roughly 20% than for corporations, partnerships, and individuals. Divided titles. The fundamental idea of a trust is to divide the legal and equitable possessory title of the trust's assets. For example, suppose Mr. Smith owns and operates a business. Because he has both legal title, he owns the business, and equitable title, he actually works the business. He hasn't leased it to someone else. Mr. Smith alone is entitled to any benefits, profits from the business. Likewise, Mr. Smith is solely responsible for any liabilities and taxes his business may incur. With full title, legal and equitable, comes full benefits and full liabilities. But suppose Mr. Smith leases his business to Mrs. Brown. Now, while Mr. Smith still has his legal title to his business, he still owns it. Miss Brown is operating the business under lease and therefore has equitable title. Because the title has been split, legal stays with Smith. Equitable goes to Brown. So how are the potential benefits and liabilities? That's an interesting thing right here. Did you see how it says right there that if Mr. Brown is operating the business under lease, Miss Brown, excuse me. Miss Brown is operating the business under lease. How many of you are doing a business under a lease? And then you have the equitable title because you're working it, right? But it says that Mr. Smith still has his legal title to his business. So legally, he owns what? The building or the business? But then Miss Brown is operating the business under lease, and she has the equitable title. I wonder if something were to happen, like somebody would fall off a step or something. Well, I'm pretty sure that Mr. Smith would make Miss Brown get insurance, right? But if it's outside, he's still the legal owner. And you know, most insurances aren't going to, what's it called? Insure you for outside. So he would be the one that would be liable for that. I'm just saying. Had to put in my 2 cents there. Okay, so because the title has been split, legal stays with Smith. Equitable goes to Brown. So have the potential benefits and liabilities. So have, did he mean to say half? I think so. If the business has a bad year, Mr. Smith is still guaranteed. Where's the next page? Okay, where's the next page? Hang on a second. I gotta find the next page. How do I do this? Oh, I think I did it. Okay, he has to be paid his lease. Is this page 2 or 3 or what? 61. To be paid his lease money in full. If the business prospers, Miss Brown receives all the benefits of the profits, no matter how large. Mr. Smith will be liable to pay taxes on the income he receives from his lease. Miss Brown will be liable to pay income taxes on any profit generated by the business. If someone falls, hey, right here on the business premises and breaks a hip, Miss Brown, who has equitable title, or the business itself, hey, will be liable. That's inside though, right? On the business premises, how about outside? That's what I was saying. Okay, so now, hang on a second, right here. Oh, Miss Brown, who has equitable title, or the business itself will be liable. Mr. Smith, with legal title, will normally escape liability. That's weird. I was just thinking, but on the property or in the property is one. How about outside? I think that's another situation. Essentially, by dividing the full title to his business, Mr. Smith has both guaranteed himself an acceptable income and limited his potential liability for business operations or mistakes. Typically, trusts also divide full title into legal title to property owned by the trust itself and equitable title owned by the trust's designated beneficiaries. In general, the trust division of title can result in significant gains to beneficiaries and minimized liabilities for grantors. For example, instead of leasing his business to Miss Brown, Mr. Smith might place his business into a trust and designate his children as beneficiaries. Mr. Smith could continue to manage the business as a trustee and receive a salary, hey, for his efforts. Hey, that works. But the profits would be divided among his 3 children. Although each child might have to pay taxes on his share of the income from the trust in a graduated income tax environment, the collective tax burden might be reduced and net income to the family increased. Okay, here's an example. Without a trust, if Smith's business generated a $600,000 annual profit, his corporate tax liability might be $250,000. However, if he placed his business in trust and divided the $600,000 among his 3 children, then each child might receive $200,000 and owe $50,000 in taxes. Collectively, the 3 children would pay $150,000 in taxes. That's for all 3 kids. Because it'd be 50, 50, and 50. So $150,000 in taxes on the same income that would have cost the corporation $250,000. Oh, that's $100,000 net to the Smith family, and good reason to use a trust. Yeah, he saved himself some moolah. He saved $100,000 by putting it in a trust. Additional benefits, privacy. We live in the information age. Information that used to be confidential and private is readily available on almost every aspect of a person's life. Privacy becomes an increasing problem. Trusts traditionally have enjoyed protected status in the area of privacy. Oftentimes, trust records are difficult, if not impossible, to subpoena. You know, the court will be like, hey, let's have all your books. Okay, in 1995, I followed a court case in Hawaii between the IRS and the owner of a car dealership. The individual's business and family financial holdings had previously been organized into trust. Oh. The trust was refusing to surrender financial records based on the precedent that trust records are private, and surrendering them could compromise the trust, and thereby jeopardize the interest of the beneficiaries. The defense attorneys had done considerable preparation and presented various court cases that substantiated the privacy of trust records. The IRS countered with the argument that in 1938, the common law had been statutized, and the cases that the defense used no longer applied because we are under admiralty law. What? What? That was the IRS's. I can't believe I got to read this again. The IRS countered with the argument that in 1938, the common law had been statutized, and the cases that the defense used no longer applied because we are under admiralty law. I'd heard the admiralty argument several times, complete with the gold fringe of the flag. While it was possibly true, I discounted its practicality in the real world. You can imagine my surprise at hearing that from the IRS's attorney. I know, that's pretty wild. Wow. The judge allowed certain very limited concessions, and the IRS was allowed to examine certain non-vital trust papers. The end result was that the IRS failed to find any fraudulent intent. The judge ruled in favor of the trust. The trust's privacy was maintained, and the case was dismissed. The case was subsequently appealed to the Ninth Circuit Court of Appeals, and again, the privacy of the trust was upheld, Court of Admiralty or not. Wills. While better than nothing, most wills can't truly protect the surviving family members from the horrors of probate and the confiscatory taxes. However, with a properly designed trust, probate doesn't exist. Probate is triggered by transfer of title of decedent's assets or decedent's assets. Assets held in trust are not subject to probate when a trustee dies. The assets do not belong to the trustee. His position is vacated and a successor is appointed to fill it. Liability. A bankruptcy case involving Arizona Governor Symington is a perfect example of limiting liability and the trust's immunity from the actions of the trustees. Before he became governor, he personally guaranteed, a development project that went bankrupt. Wow. When he was sued, his lawyers responded that all the Symington family's wealth was in trust, and that the trust could not be forced to honor the governor's personal debts. The lawyers went on to say that they were dropping their defense and that no check would be written in the foreseeable future. Imagine a legal entity so strong, the lawyers wouldn't even bother to defend it. A properly administered trust is nearly impossible to penetrate to satisfy personal debts. The Supreme Court affirms the liability protections of the trust. Further, the primary objective of a trust relationship is to obtain the advantages of corporations, but with the freedom from the burdens, restrictions, and regulations generally imposed upon them. Ashworth versus Hagen Estates, 165 VA 151, 181, SC 381. Income tax. Income taxation of trusts and potential tax savings to the creator of the trust is not a matter of opinion but fact. Trusts are recognized by the IRS and are issued tax ID numbers. The trust files its own tax return, which is an IRS Form 1041. Any lawsuits or back taxes charged against a trust business or property would be limited, let me move this over here, to seizing only those assets contained in the trust. If the IRS tried to collect back taxes on Mr. Smith's business, they might be able to seize the trust business, but could not seize Mr. Smith's home or car or bank account, which were not assets of the trust. What if your bank account is the trust account? Yikes. For tax purposes, the IRS separates trusts into 3 categories: simple trusts, any trust where all the trust income is distributed annually; grantor trusts. Since the IRS tries to define most trusts as a grantor trust, it follows that this classification is not necessarily to the trust's advantage. And complex trust, defined as a trust that is not a simple trust. Note that the IRS does not determine whether a trust is statutory or contractual, or impose any restrictions on who may create one. They merely try to categorize trusts for tax purposes and process the correct tax forms once the trusts have been created. Nevertheless, it's curious that the entire IRS definition of complex trusts consists of a description of what they are not. Black's Law Dictionary is less mysterious and defines complex trusts as those where the trustees have complete discretion, power, over the administration of the trust assets. In fact, the complex trust has the greatest degree of flexibility and freedom from statutory encumbrance. Without getting bogged down in definitions, note that it is possible to have 2 kinds of complex trusts: those formed under statutory law and those formed by private contract. As we'll see, a complex trust established in contract, not statute, is the best way to form a trust. That's cool. So a complex trust established in contract. So statutory versus contractual. There are basically 2 classes of trusts. The first is a trust established in statute by the legislature. Black's Law Dictionary lists over 85 different types of statutory trusts, including living trusts, discretionary trusts, pour-over trusts, etc. Statutory trusts derive their existence from Congress and can be altered, amended, or revoked by Congress. For example, living trusts, at best, protect the estate only up to $1.2 million. Worse, there's been an alarming trend for the past several years in which living trusts are often set aside by the courts and the estates probated anyway. Wow. As a result, the living trust estate is subjected to ruinous legal fees and taxes. Is it a matter of time until living trusts are set aside entirely? Remember, Congress created the living trust. They are statutory. What Congress creates, it can amend or revoke. Have you ever heard the saying, ignorance of the law is no excuse? In the realm of statute, you are liable for laws that you aren't even aware of. For example, you're driving down a road and the speed limit lowers and you don't see the sign. Oh, what happened? Darn it. Okay, wait a minute. How do I get it back? What happened? Okay, where are we? Okay, so okay, for example, you're driving down the road. Okay, lowers. Okay, so you continue on at your previous speed in blissful ignorance until you are caught on radar and given a ticket for speeding. You explain that you had no idea that you were exceeding the limit. It doesn't matter. You are liable whether you knew it or not. That is pure liability. It doesn't matter what your intentions were. You didn't mean to break the law, and you probably wouldn't have if you hadn't known. It doesn't matter that there was no criminal intent. Okay, now I gotta find the other page. Oh, yes, I did it. Cool. Okay. Or harm done. The simple fact is that you were in violation of the law. Move the little thing in it. It moved my screen. Okay. What page are we on? Okay, there. Page 63. The simple fact is that you were in violation of the law and the price must be paid. The realm of statutory law is the realm of pure liability. So we don't want that. If you choose to put yourself into that realm with a statutory trust, you better have a good lawyer. The second class of trust is established in contract. The very definition of a trust is a contract involving three parties. Oh. So the first party, grantor, creates a trust and typically conveys property into that trust. Okay. The second party, trustee, so there's a grantor, and then there's a trustee. Got to get a trustee. Okay, the second party trustee administers that trust for the benefit of the third party, which is the beneficiary. Could be your kids or your grandkids. So trusts are typically formed by a contract between the grantors and trustees. Beneficiaries play no active role in the trust creation or administration. The legal significance of contracts was of supreme importance to the framers of the Constitution. Article 1, Section 10 states, no state shall pass any law impairing the obligation of contracts. The guaranteed right to contract is evidence of the people's sovereignty over government, and that once a lawful contract, private law, is entered into, even Congress cannot pass a subsequent law to revoke or impair an existing contract. Darn it. I just did something weird. What happened? I hate it when this happens. What? Okay, there it is. Gotta be touchy. The guaranteed right to contract is evidence of the people's sovereignty over government, in that once a lawful contract, private law, is entered into, even Congress cannot pass a subsequent law to revoke or impair an existing contract. This guarantee is far more important than most people imagine. For example, suppose a farmer has a contract to receive payment for the crops that he delivers to market. If the contract is not honored and he's not paid for his crops, he'll have no incentive or money to produce crops the next year. Instead, he'll only produce enough to feed himself and his family. If no one could depend on contracts, there would be no incentive to produce anything. Production would halt and factories would close. There would be nothing to sell. The stores would be empty and almost all commerce would cease. The right to contract is crucial to the existence of free market and even personal freedom. As proof, consider those communists and socialist societies whose governments are able to impair the obligation of existing contracts. See? Although even the most repressive governments preserve some measure of the right to contract, to the extent that right is restricted, those societies are characterized by poverty and political oppression. The United States Supreme Court affirms the right to enter into a contractual relationship, trust. The contract trust relationship is based upon the common law and is not subject to legislative restrictions, as are corporations and other organizations created by legislative authority. Crocker versus McCloy, 649, U.S. Sup. 39 at 270. Example. If Congress didn't create a contract, it can't lawfully alter, amend, or revoke it. Nevertheless, can Congress pass laws restricting the ability to utilize trusts? Yes, but not likely. Virtually all our elected officials use blind trusts, a trust that is listed in a registry in Washington, D.C., and does not report the source of its income. Oh, IRS 1041, Instruction Book, page 7. I'll have to read that. In light of the power and wealth of those who already use trusts, it is unlikely that legislation restricting trusts will become too severe in the foreseeable future. When creating a trust, remember that since a trust is a contract, private law, which can be freely entered into, there is little or no need for statutory trusts of any kind. And as you'll see, contractual trusts offer far more advantages than statutory trusts. Therefore, the subject of trusts can be hugely simplified by ignoring statutory trusts and focusing entirely on contractual trusts. Grantors. A trust begins with the grantor, who typically not only designs and creates the trust on paper, but also endows it with some of his valuable assets, land, businesses, money, etc. Once the trust is created and endowed with assets, the grantor must disassociate himself from the management of the trust. And the assets he placed in the trust, or the IRS would cheerfully classify his creation as a grantor trust and tax him accordingly. That's interesting. Trusts can be revocable or irrevocable. If a trust is revocable, the grantor has the legal power to take back whatever property he put in trust. This may seem like a safety feature in the event that a person changes his mind, but in reality is a gaping hole in the trust's armor. In the eyes of the courts and IRS, if the trust is revocable, meaning I can take that back, the grantor technically still owns the property he placed in the trust. If he owns it, he can be taxed on it or even have it taken away from him in a judgment. Therefore, to minimize IRS intrusions, it is vital that trusts be irrevocable. Yay! That's what I have. Example, the grantor retains no residual or revisionary power over the trust, and therefore cannot tell the trustees what to do or take back his property. The idea of permanently surrendering all control over your property to the management of others is a scary concept for some people, but it is key principle and essential attribute of the term trust. It is a simple matter to make a trust irrevocable. The grantor simply declares it irrevocable in the trust indenture, the document which created the trust, and it is legally so because when the grantor creates a trust, he is literally creating law. Wow, that's cool. That's cool. The people making law? What a radical concept. Exactly what is meant by holding we the people as sovereign over our government. If a trust finds itself in court for whatever reason, the judge must use the trust indenture as the guide for how the trust is to be treated. Remember the Constitution's Article 1, Section 10, prohibition against impairing the obligation of contracts? When assets are conveyed irrevocably into trust, the tax liability of the assets no longer attached to the grantor, while the tax deductions for individuals are disappearing one by one, deductions for trust have remained almost perfectly preserved. Therefore, why do so many competent professionals disagree on this point? It is because the lack of familiarity with trusts and their potential. I repeat, The principles and laws pertaining to trusts are not complicated. They are just not widely known. Details pertaining to taxation of trusts are available from a variety of reliable sources. One of the sources I reference frequently is Practitioners 1041 Desk Book, Practitioners Publishing Company, Texas. Trustees, there's a great deal of difference between being a grantor who places property into a trust and a trustee who manages assets for the trust. Some grantors go to great pains to create a trust and still retain control over the assets by making themselves managers or protectors. They do this because they don't understand the concepts of trusteeship or irrevocability. Assets conveyed irrevocably are transferred into trust, just as if they were sold. So long as the grant is irrevocable, the settlor or grantor may make himself sole trustee or one of several trustees. Trust 6th edition, George T. Bogert. Therefore, the grantor may administer the trust as trustee. Did you hear that? The grantor may administer the trust as trustee without retaining any residual power or interest. The court agrees by declaration of trust, the legal title, possession, and control of the trust estate passed irrevocably from the grantor as an individual to himself as a trustee. Let me read that again. The court agrees by declaration of trust. I have a trust. The legal title, possession, and control of the trust estate passed irrevocably from the grantor as an individual to himself as a trustee. From the grantor as an individual to himself as a trustee. The effect is no different than if the trustee had been another person. Helvering versus St. Louis Union Trust Company, 296 U.S. 39, ante 29, 56 S. Court 74, 100 ALR 1239. If a trustee understands his role and administers the assets for the benefit of the beneficiaries, there is no danger of the trust failing for that reason. Trustees in a properly created complex trust have complete discretion and broad powers over the administration of the trust and its assets. Although trustees must follow the trust indenture, as a general guide, no one can tell the trustees what to do. Trustees may even amend and add to the trust indenture. The courts have ruled that in order for a contract trust to fail, the trustees must willingly and knowingly commit fraud. A trustee will not cause a trust to fail because he makes an administrative error. The courts recognize that the trustee's job is not to be a lawyer, but a custodian or steward over the assets. Historically, there is a great deal of leeway given to trustees in the administration of their duties. Fraudulent intent must be proven. Intent is much harder to prove than a simple mistake because of oversight. Essentially, if a trustee makes a mistake, he must correct it, and having done so is personally immune from any civil or criminal liability. Liability cannot be assessed to a trust because of the actions of a trustee. Similarly, the trustee is not liable for the debts of a trust. However, a problem will arise if the grantor also makes himself both a trustee and a beneficiary of the trust. It is a hard and fast rule of trust that trustees cannot also be beneficiaries. However, additional assets like houses, cars, etc., can be purchased by the trust and conveyed into the trust as trust property. This can be accomplished with no tax liability to the former grantor, now trustee, who resides in the trust's house or drives the trust car. Although there is some dispute among legal and accounting professionals, the trustee may occupy the house or drive the car at no charge or tax liability to himself. There are numerous letter rulings involving the IRS where the person occupying the house, equitable or possessory title, is not assessed income, and the entity that owns the house, legal title, is allowed the deduction. The pivotal point is contract. The trustee or employee may occupy the residence if it is a condition of employment and stipulated in the employment contract. The same rules apply with respect to a car. In the absence of a contract, the point is less defensible. So I guess you got to have a contract. Complex irrevocable trusts. Trusts are powerful tools for estate planning and administering assets. By entering into a complex irrevocable trust, you can elevate your family and business financial dealings to a higher plane and be ruled under non-statutory sets of laws. The benefits of trusts are available to anyone who freely elects to use them. A degree of privacy and protection from liability can be achieved. That is otherwise unavailable. Probate can be totally avoided, income taxes reduced, and personal liability virtually eliminated. It is reasonable and prudent for a person to reorganize his affairs so that he may enjoy better privacy, protection, and improved tax position. The courts have ruled specifically that a person is not more or less patriotic because of the amount of taxes he may or may not pay. Additionally, a person may choose to organize his affairs whether or not the resulting benefit or tax savings are incidental or by design. Many of the benefits of trusts can be achieved using corporations and other statutory entities. However, the contract-based complex irrevocable trust is clearly protected by the courts for various reasons. Given a choice, I would rather have the protection of the courts than to have to depend on my wits or luck to keep me out of harm's way. And that was from Glen Halliday, is associated with trust affiliates and a member of the Fiduciary Educational Society. For additional information on trusts, contact Glen Halliday, 4718 Meriden Avenue, 264. San Jose, California, 95118, trustlaw.org. And it looks like you can order from Anti-Shyster, 156 pages, $30. Learn the Constitution. Cool. All right, well, that was a perfect amount of writing because now I'm getting sleepy and it's bedtime for me. If you like this video, watch it again and again, share, comment down below. Please subscribe. I get a lot more views than subscriptions, but you know, I'm going to be popping up with different things, different special guests. So just get on that subscription thing and do that little bell so that you can get notified for the next thing. All right. Have a good evening. Good night. Sleep good.